Good morning, everyone, and welcome. Thank you for joining us in today's session of monthly legal updates for Canadian employers series. This is entitled "When the Employment Relationship Ends, Legal Risk Doesn't." That tagline got my attention. My name is Scott Sweatman. I'm the leader of the Pension Benefits and Executive Compensation practice at Dentons Canada. I'm based in Vancouver. I have over 30 years experience advising pension plans, pension plan advisors, executive compensation, related tax matters. I work with national and multinational organizations on regulatory compliance, governance, and complex compensation structures, including what I hope are practical strategic approach to these issues. I'm also had the pleasure and honor of working with the four individuals I'm about to introduce. So I'm pleased to be joined by my colleagues across Canada. Craig Lawrence is a partner in our Toronto office. Craig's practice focuses on collective bargaining and grievance arbitration, union certifications, and work stoppages. Christina Wendell is a partner in our Edmonton office. Christina leads the Edmonton employment practice and labor practice, and Denton's Alberta occupational health and safety practice, advising employers on compliance, incident response, investigations, and defending OHS charges. Catherine Coulter, counsel in our Ottawa office, who I also work with a lot. She leads the Denton's Ottawa Employment and Labor Group and brings 3 decades of experience guiding clients through the full employment life cycle and resolving workplace disputes. Finally, I'm joined by my associate, Rachel Akindemi, associate in our Vancouver office. Rachel assists clients with a range of complex matters, including wrongful dismissal claims and human rights complaints. So you've got a great lineup this morning or afternoon, depending on where you're calling in from.
Thanks, Scott. So like said, I'm going to be talking about releases today. Next slide, please. So just a brief introduction in terms of what is a release. Release is effectively a contract. One party is giving up their right to sue, their cause of action against the other party in exchange for some form of consideration, the quid pro quo. Now, what a release is not the same as a contracting out. So a lot of the legislation that you're going to want covered by a release, human rights, employment standards, those are pieces of legislation that employers and employees cannot contract out of, but that's not what a release is doing. And I'll talk a little bit more about how that works in terms of future claims and those types of pieces. Releases, of course, commonly used on termination. So most of the examples that I'm going to be talking about arise in that context. They can also come up in separation agreements where there's a mutual agreement for the parties to separate, and then also in resolving claims and legal actions. Next slide, please. What I'm going to be going through is some of the do's and don'ts, and primarily they flow from what is still the leading Alberta case, even though it's now over 25 years old, in Chow and Mobil Oil. And so that's the case that laid out whether it's the court or the Human Rights Commission that has the ability to decide if a release is enforceable or will bar an action, and also sets out the factors to be considered when making that decision. So starting out with the first do ensure adequate consideration. And the important point here is that the employment standards minimum entitlements are not consideration for a release. So if all you're paying the employee is their statutory termination pay, that is not going to give you an enforceable release. So there has to be something over and above that. Do use clear and specific language. If you're looking to cover certain statutes, typically employment standards, human rights, specify the actual statutes, name them in the release. Also, if this is a release settling an action or a complaint that's already been filed and in process, include a specific reference to that action or complaint. And also just keep it simple, avoid the legalese as much as possible. Just make it easy to read, and that will help you as the employer on some of the other considerations, like when we're talking about duress and other factors that could make an release unenforceable. Do give the employee time to consider the release. Usually on a termination, I'll say 5 to 7 days is reasonable, but if the employee comes looking for an extension, I will, it is very rare that I'll advise an employer to say no. And then even if they need more extensions, I'm generally pretty open to that without taking issue. Next slide, please. Do consider the potential for a claim of duress. So duress is one of the things that can make a release unenforceable if there's a finding that the employee was under duress when they signed the release. And one of the ways that that can arise if there's issues of timing and financial need. Now, it's not any time an employee is under pressure and financial need that that's going to give rise to a finding of duress. It has to be something where the employee essentially can show that they signed the release against their own free will. Do encourage the employee to seek legal advice. That's generally part of the actual release where the employee is required to sign off on the fact that they had the opportunity to do so. And certainly you can encourage the employee to do so when you present them with the release. Now, if you're federally regulated, do be careful where the Canada Labor Code applies. As you'll know, there's provisions under the Canada Labor Code that give the employee the additional ability to file an unjust dismissal complaint a short period of time after the termination. And those types of complaints may not actually be barred by a release. So if you're federally regulated, you do have to be careful with that. Next slide, please. Do document the process. So many times, if there's an issue and the validity of the release ends up being in dispute later on, it's a matter of months or even years before that can be decided if it's going through a court or tribunal process. So by the time the parties are actually before the adjudicator, memories have faded. Employees will say, well, I don't remember signing it. I don't remember what happened. So to the extent you can document everything and keep records of that, that will be very helpful down the road if there is a challenge about the release. So including when and how the employee returned the signed release. You know, it was sent via email on this date, or it was dropped off at the front desk and so accepted it. Keep records of all that because that can be very important down the road. Do consider potential limitations on confidentiality and non-disclosure clauses. So those are becoming more and more, I guess, important or more and more talked about. So that really comes up in harassment, sexual assault type cases, and really spurred on by the Me Too movement a few years ago. The US, I believe, has barred non-disclosure agreements or confidentiality clauses in those types of settlements in many states. In Canada so far, I understand Prince Edward Island is the only one that has legislation that generally covers those, and that prohibits non-disclosure agreements in certain circumstances. My Ontario colleagues could correct me, but I believe there's some provisions in Ontario, but limited to the post-secondary world. Now, you know, there's mixed views on whether those should be, whether confidentiality and NDAs in settlements should be prohibited or not. It is obviously an important incentive for an employer, and there's views on both sides. In Alberta, I'd say a confidentiality clause is considered part of a standard form release still, but we'll see. There may be more coming down the road. Next slide, please. Now, this is kind of repetitive from my first do, but it's an important one. So don't forget to carve out the employment standards minimum entitlements from the consideration. So you'll want to just make it very clear on the termination that the employee is going to get their employment standards minimums regardless of whether they sign the release. There's been multiple cases where the employee claimed, well, no, I thought I needed to sign the release to get my employment standards minimum, so I felt forced to do that. So you want to really set that out clearly in the termination letter, and also just when you're having the termination meeting, just make that very clear to the employee. Don't let the employee sign the release at the termination meeting. So you may have a very easygoing employee who reads over the offer, the release, and they're like, "Yeah, you know what? That sounds good. Where do I sign?" Picks up a pen and purports to try and sign it right there. My suggestion in those instances is don't let them. Require the employee to actually take the release away, give it some thought, consider it, and then give it back to you if they still want to sign sometime later on. Uh, Now, this one should go without saying, but it is still in a case. Don't forge the employee's signature on the release. So there was, again, a recent Alberta case that I came across when looking through this, where that was one of the things that the employee was raising. They claimed that they had no recollection of signing the release. That was not their signature on the document. They were alleging that the employer had forged it. Of course, the employer denied it, but and I didn't find an actual decision, an end decision. This was at the human rights level, but it was the employee had put in enough evidence to require a hearing into that issue. So that was just an issue that then had to be dealt with in a hearing. Next slide, please. Don't pressure the employee to sign the release. So sign now or the offer's gone. This is a one-time only offer. Those types of tactics can invalidate the release later on. The things that some of the factors that are looked at, whether there was coercion, oppression, abuse of power, authority, or compulsion, all of those are items that can invalidate a release. Don't include items that cannot be released. So future claims in particular. So a release can only cover things that have happened, claims that exist as of the date of the release. They can't cover something that happens down the road. Certain statutory elements. So in Alberta, you can't release workers' compensation claims, for instance. The employee still has the right to file a WCB claim, and occupational health and safety complaints in terms of the safety complaints. So if there's a safety concern or the right to refuse unsafe work, those cannot be released. We have disciplinary action complaints in Alberta, and those generally can be covered by a release in terms of the remedy available for the employee. Next slide. Don't request a release from an employee who does not have mental capacity to sign it. So where there's a concern that the employee does not have the capacity to enter into an agreement, you may need to get some doctor certification or look at other ways. Now, that's not going to be every case where there's a mental disability at play. It has to get to the point where there's a real concern about capacity. Don't ask the employee to sign the release while they're still employed. So the way this can come up is if there's a package that includes a period of working notice with a lump sum at the end, for instance. Don't let the employee sign it while they're still working because, again, going back to the point where a release can't cover a future claim. So what I'll usually do is present the offer, the employee can accept it, and part of the acceptance, they agree to sign a release on or after their last day of work. And then the last point there is just don't panic. And this ties into that. Don't panic if an employee accepts an offer but then refuses to sign a release. The settlement may still be binding on the employee, even if they haven't done, though, as long as it can be shown that they accepted the offer. And there was a recent case, the Stribling and Starbucks case. I think I'm out of time, so I won't delve into a lot of detail. But essentially, the employee had some time, had some extensions for the offer, ended up sending an email that said, I've decided to accept your offer, referenced the specific date of the letter that contained the offer, promised to sign the release when it was sent to them, got the release, instead sued for wrongful dismissal. The court said, this wasn't an agreement to agree. The terms of the agreement were fixed. The employee had accepted the offer and was bound by it. So with that, I will pass it off to Rachel.
Thank you very much, Christina. Good day, everyone. Thank you for joining us today. So I'll be speaking to you about the change substratum doctrine and discussing a recent case where the BC Supreme Court reaffirmed the scope of the doctrine. For some of you who are not familiar with the concept, next slide, please. Yes. So for some of you who are not familiar with the concept of the change substratum doctrine, it is basically a concept that recognizes that an employment contract may be invalidated due to significant changes to an employee's role or other key terms of employment. So where there has been fundamental changes to, for example, an employee's tied to their position, their salary, or their reporting relationships. This may in turn render the termination provisions in their original contract unenforceable. And then this might then trigger common law reasonable notice, which is usually higher than what might be provided for in their contract or the statutory minimums. So basically, this doctrine prevents employers from relying on outdated contracts where the employee's role has fundamentally evolved beyond what the parties originally agreed to. And so sometimes determining what is a fundamental change is very fact specific. But as we can see in La Plume, sorry, can we get the next slide, please? Yes, so as we can see in La Plume and AA Internet Publishing Inc., so in September 2013, the employee commenced, Mr. La Plume commenced providing services as an independent contractor to AA Internet Publishing. And then in December 2013, he entered into an employment contract with the employer as a junior developer. And some of his core duties involved testing games and writing configuration files for the employer. So from 2015 to 2019, he received a couple of salary increases. However, this was not backed by any form of promotion or change in his duties. Then in January of 2021, he was appointed as the manager of the games team, which came with another salary increase. And then he was responsible for managing a small team while also continuing his core duties of testing games and writing configuration files. However, there were no other changes to terms of his employment, so his hours of work, his work location, and reporting structure remained the same. Then in 2022, he was promoted to the operations manager with another salary increase. And then he was also responsible for training new hires on game configurations. However, he continued to perform his core duties of testing games and writing configuration files, and there were no other changes to his to the terms of his employment. Then in July of 2023, his employment was terminated and he was paid his termination entitlement in accordance with the contract he had entered into in December 2013. Next slide, please. And so being dissatisfied with what he had received based on his contract, Mr. Laplume filed a claim for wrongful dismissal and he sought common law notice. So at this point, it's important to note that throughout his employment contract was never amended. It was never replaced, even when he received all of the salary increases, when he became the manager of the games team, or when he became the operations manager. However, so basically, Mr. Laplume was arguing that his employment contract had been nullified due to the fact that his key roles had changed significantly over the years. Basically, he argued that his employment contract did not reflect the significantly higher level role of an operations manager. However, his employer argued that the changes that were made to his employment were not fundamental or dramatic to alter his employment contract. So basically, his employer was arguing that these changes were only incremental and predictable and in line with the experience he had gained over the years. Also, his employer also relied on the fact that his employment contract had also expressly stated that if there are any changes to his employment, such changes would not constitute a breach of his employment contract. And so the court then noted that, yes, despite the fact that the employee had claimed that his employment had changed significantly over the years, it was only twice that his position had changed, and that was when he became the manager of the games team in 2021, and the other when he became the operations manager in 2022. So the court accepted that, yes, the changes in the employee's employment led to an increase in his duties and responsibilities. So basically, he gained more responsibility over others, and he was training other team members and helping them to, and basically training them and having a responsibility over a small team of new hires. So, however, despite those changes, All of the core duties of Mr. Laplume's employment stayed the same. He continued testing games, he continued writing configuration files. So basically, he was still working as a junior developer with some of those added responsibilities. And none of his the other key terms of his employment had changed. So he continued to report to the same person he had been reporting to since the beginning of his employment. His hours of work didn't change, and then his location of work also did not change. And so the court held that such changes to his employment were not dramatic or fundamental or significant, and that his employment contract had also anticipated those changes, and therefore his termination clause was still enforceable. And so the change substratum doctrine did not apply in this case. However, we may, like I said, the analysis of whether or not the change substratum doctrine would apply is quite fact specific. And we can contrast this with another case from the BC Supreme Court, which is from 2004. But then in that case, in Smith and Amek Earth and Environmental, the employee had basically started as a part-time assistant to a business manager. And then at the time of the termination of their employment, they essentially became a business manager, earning more than 5 times their starting salary. And in that case, the court considered that the nature of their job had actually changed fundamentally. It had changed so much that basically it wasn't the same job they had when they were hired, right? So in that case, the change substratum doctrine applied. So now comparing that to the case at hand, the Laplume case, basically for Mr. Laplume, all of the other aspects of his employment remained the same. He continued testing games, he continued writing configurations, and the only thing that basically changed was the fact that he got like an added managerial responsibility. Yes, even though the court accepted that, getting a managerial responsibility might lead to changes, in this case, those changes were basically incremental based on his experience. So due to the number of years of experience that Mr. Laplume had, it was only reasonable for him to be able to train other new developers coming after him. And so the court also emphasized the fact that his employment contract had stated that or any changes to his employment would not lead to a breach of his contract. So that was one very important fact of that case. Can we move to the next slide, please? Thank you. And so the court basically summarized the principles relating to the change substratum doctrine as follows. So the first one is the fact that significant changes in employment can render an employment contract unenforceable by the time of termination of employment, where, for example, the foundation of the employment contract entered into at the time of hiring may have disappeared by the time of termination, or it may be implied that the contract could not have been intended to apply to the position ultimately occupied by the time of termination. Yes, and however, not all of these changes in employment benefits, the duties and responsibilities would be sufficient to erode the foundation of the employment contract. And so in order to erode the foundation of the employment contract, the change has to be dramatic and fundamental. Like, just note the words dramatic and fundamental. It has to be very different from what was initially agreed to, as we saw in the case of Smith. And so incremental and predictable changes in the terms of employment and insufficient basis on which to conclude that an employment contract is unenforceable. And so if the changes are seen to be incremental or predictable based on the skill set, based on the experience that the employee has, in such situations, most times the court would, if those changes are seen to be incremental and predictable, the court would hold that the change substratum doctrine does not apply. Then the last point the court also made was that where an employment contract anticipates and permits changes in employment, the change required to erode the foundation of the contract must be beyond what was anticipated and permitted. So in as much as even if the contract basically states that changes to the employment would not be a breach to the employment contract, it has to still be within the limit of what has been anticipated or permitted. Next slide, please. And so what are some of the key takeaways and some of the ways to mitigate the application of the change substratum doctrine. So the first one would be to include clauses in employment contracts, confirming that the contract will continue to apply despite changes to the employee's terms of employment. And I would say personally, this is one of my favorite clauses to include in employment contracts. Then the next thing would be to also review employment agreements periodically, especially when there's been changes to an employee's terms of employment. And also in situations whereby you believe the change substratum doctrine might apply, it would be good to consider having employees sign a new employment agreement, which has to be backed by fresh considerations such as a pay increase, bonus, or enhanced benefits. And the last one would be to also just ensure to maintain accurate records of all changes to employment terms and conditions. And that way it just makes things easier if something like this comes up. So now I will just pass it on to Craig, who will be speaking about retirement and resignations.
Thanks, Rachel. And as she said, I am going to be talking about resignations. This is a great area of the law where the test on paper could not be clearer, and yet lawyers and the courts and employees and employers have found boundless ways to make it as messy as possible. So let's talk about the core test itself and how simple it looks on paper. All you're looking for is really three things. Is a resignation voluntary? Is it clear and unequivocal? And has it been accepted? So on its face, it's quite simple. There's really just these three elements, but it uses both a subjective and an objective analysis when we're assessing what's actually happened. And what the court is asking is not to get inside the employee's mind, but to ask, was the employee's conduct or words communicated in such a way that a reasonable person would understand that they were resigning from their employment? And it's really important to know that the employer is the one who bears the onus in establishing that a resignation actually took place, in establishing that it was voluntary, and showing that it was clear and unequivocal, and in showing that they accepted it. So it's on us to establish that these three elements exist when a resignation takes place. So let's go to the next slide and think about what our biggest enemy is when we're thinking about resignations, and it's always ambiguity, right? A resignation needs to be clear and unequivocal, and we know that there's a whole host of behaviors that don't qualify as clear and unequivocal. One is sort of the rage quit, right? I quit, and they walk out in anger. Those are people that have made a hasty decision. And the courts have been quite clear that, a resignation tendered in anger probably is not clear and unequivocal. Now, the way in which they have tendered it and the number of expletives that they've used or personal attacks or threats against the people that they're communicating with, those things might give rise to termination for just cause. But the angry resignation itself is rarely going to be grounds to say that it was clear and unequivocal. Similarly, just getting up and walking out of a meeting, that's not enough. Expressions of unhappiness, conditional resignations to say, well, if you don't change this, I'm going to resign, right? That's a conditional resignation. It's not a clear and unequivocal statement of what you are actually going to do. One of my favorites of this sort of bucket of behaviors is the classic, I'm going to retire at the start of the new year. You get it in an email, maybe it's in the fall of the year prior, maybe it's a long service employee who's making a lot of money. You know that they're going to be expensive if you do decide to exit them in the future on a without cause basis. And so you get that email and you think, oh my God, this is an out from a significant financial liability. But when you think about it, what does that email really mean, right? I'm going to retire at the start of the new year. All right, is that January 1st? Well, that's a holiday. Is it January 2nd, right? The first business day. Well, what if by New Year they mean the fiscal New Year? And what if your fiscal year runs from April to March? What if by New Year they mean the fiscal New Year after bonuses are paid, right? Maybe there's the annual bonus compensation piece that is factoring into their thinking on it. Ambiguity is a problem, and the onus is on us to dispel that ambiguity by talking to the employee, by asking these questions. We can't sit on our hands and rely upon an email that has those types of ambiguities baked into it, those uncertainties baked into it. Um, and it's important to understand that context can override even a written resignation. There are quite a few cases actually where people have tendered resignations in writing, employers have accepted them, but then the court has really gone back to evaluate whether or not those original resignation letters in writing were clear and unequivocal. A really classic example was an employee who had about 25 years of service. The employer plans to introduce a new HRIS system. She's not computer savvy. She's not tech savvy. She's carrying a lot of anxiety about this changeover. And so she writes an email to her employer that says, I'm going to resign. I can't be part of this new HRS system. It's not something that I'm totally sure I want to do, but I'm not going to be able to master this. So I think resignation is the only path forward. The employer writes back, accepts the resignation, but throws in, sort of like the throwaway kind line, if you change your mind, let us know. Well, as it turns out, a couple months later, the system was never introduced. And so the employee went to rescind her resignation and to say, well, I don't want to resign if that new HRS system's not coming in. I want to stay. And the employer said, well, you can't stay. In fact, we've found someone else who's going to do this role. We've already put an offer out. They've already notified their employer. So that was a case where the court was essentially tasked with assessing, all right, well, was the resignation clear and unequivocal? No, it wasn't. Did the employer accept it? Well, they did, but they didn't do the initial question of asking, was it voluntary? Was it clear and unequivocal? And in fact, what was the employee actually intending to do with their words and actions? And that voluntariness piece is really, really important. Voluntariness is a threshold requirement when we're looking at resignations. If it's not met, the analysis ends. It doesn't really go any farther than that. So even if you have a resignation that's clear and unequivocal, it will be legally invalid if it wasn't made by the employee's own free will. So if they feel that they were pressured into it, if they were under duress when they made it, and that can take lots of different forms. It can be a disability where the employee lacks capacity. It can be, a human rights matter where they are tendered a resignation because they have a family status issue or a childcare issue that they can't seem to resolve. And we haven't engaged with them proactively as part of our accommodation functions and responsibilities. So assessing voluntariness, understanding whether or not this has been tendered, from a place of, clear-eyed thought and deliberation, is important. And again, the onus is on us to show that it was indeed voluntary. That last piece, acceptance matters. Okay, well, we need to accept a resignation. We can't, again, sit in silence even when we get a clear and unequivocal one on our desk. We have to respond back to them and say, we accept your resignation. It will be effective on X date. We'll be processing your paperwork, all that normal normative stuff. That communication has to happen. And we always recommend do it in writing. Make sure there's something on paper that we can rely upon. Critically, we can't change the terms of that resignation in accepting it. So we have to accept it on the employee's terms. If they say, I'm going to retire on February 1st, 2027, we can't respond and say, great, we've accepted your resignation effective January 27th. Right? That's not acceptance. We can't unilaterally change the terms. We can't change the date. If they say, I'm going to retire at the end of this project, well, then it's on us to go and figure out when the end of that project is and to communicate that back to them. We have to be the ones who are taking the responsibility of ensuring there's certainty of terms on both sides of this agreement. Let's talk about revocation relatively briefly here, right? The great sort of boogeyman of resignations. Can an employee rescind the resignation? When can they do so? So in general, if an employee seeks to rescind their resignation before it's been accepted, they can do so. After it's been accepted in writing, it's generally binding. Now, it used to be the case law was much worse for employers, and it was very much about detrimental reliance. And could an employer establish that, sure, even if they'd accepted a resignation, had they taken steps and relied upon that resignation to their detriment? Had they hired somebody else? Had they changed their budget forecast? Had they shrunk their footprint, their office footprint? All of those sorts of factors that you would point to used to be critical to it. And really, over the last few years, the analysis has shifted towards saying, no, all we really need is something to be voluntary, clear and unequivocal, and for it to be accepted. And once it's accepted, it will be binding. The problem, of course, is that judges are human. And even within this kind of new sort of reweighted framework, there's still broad discretion for a judge to decide whether or not that resignation was clear and unequivocal. So sort of the same analysis we used to play around in with detrimental reliance, you're still jumping through hoops when you end up in court, arguing about whether something is clear and unequivocal. And judges will generally jump upon ambiguities and try and create outs because most of the system is weighted in an employee's interests, and the rights that an employee gives up from a resignation wrongly thought through are significant. So, once a resignation is clear and effective, courts are generally reluctant to allow them to rescind it afterwards, but that clear and unequivocal analysis is still, I think, front and center and still provides a lot of avenues for a judge to wade into it. And again, think back to that sort of the classic employee who says, "Well, if you don't, I'm going to resign because of this HRS system." Um, a conditional resignation is not clear and unequivocal. And so think back to those old cases that puts the onus on us to go to them and make sure that there's clarity about what's going to happen going forward. And the key distinction, as we say, is this. If the resignation is equivocal, it can be withdrawn. If it's clear and accepted by the employer, the courts will generally treat it as binding nowadays. So let's talk about what resignation is not very quickly. Resignation is not job abandonment, right? These are two very different things. A resignation is about an express communication of our intention to quit. And job abandonment is about an inferred intention, right? We're looking at an employee's conduct. They stopped coming to work. They stopped responding to our communications. They didn't come back after a leave or a layoff, right? That's about us inferring what the employee means by their actions. That's something very different from a resignation that still at its core requires an expression, a clear expression of the employee's wishes and intent. So for job abandonment, the same things that we would look at historically remain true, right? With an abandonment situation, the onus is on us to, again, contact the employee, document our outreach efforts, give them an opportunity to explain why they, haven't come back to work or haven't come in and responded to our inquiries, and to confirm it in writing. The thing that's most common between these two creatures is that the onus is on us as the employer to actually do the heavy lifting and do the work to suss out what an employee meant to do and to defend the decision that we ultimately reach if our decision is challenged after the fact. So practical takeaways, very simple, very clean. Again, on paper, easy to do, but as humans, we fail spectacularly at this all the time. If you're going to accept a resignation, assess its clarity, clarify any ambiguity. So ask the questions. I know sometimes it can feel like you're looking a gift horse in the mouth when you have this, resignation email and you think, gosh, I really don't want to, have this person reconsider. Generally speaking, you're far better off to clarify any ambiguities, make sure that there's a clear understanding because the risk is a lot harder to undo after the fact. Assess voluntariness, and then document that acceptance. Make sure we're responding in writing that we have something to rely upon if the employee does try to turn around a year or two later and argue that they never actually resigned in the first place. And if you can do those things, if you can do them consistently, you're going to have success. And if you have questions, always reach out to your counsel. And with that, I'm going to hand it over to my partner, Catherine, and she is going to speak to equity on exits. Over to you, Catherine.
Thanks very much, Craig. Very informative. So you're going to see this cover slide here, equity entitlement on exit. And some of you are going to panic and go, okay, time to turn off the webinar, time to do some other work and wait for the Q&A. I'm going to give you 4 good reasons why you want to stay on this call to hear about equity comp on exit. So first of all, I've got a couple of memes in the presentation and what can be better than memes. Secondly, if you like to geek out on the law, I do, some other people do, then this topic is for you. Third, if you've got any sort of equity that your company offers to employees, you're going to need to hear this. And lastly, even if you don't have equity in your company, if you work in HR, if you work in finance, if you work in operations or law, this area actually ties into key areas around what sorts of total compensation employees are entitled to during common law notice periods. And you really need to be aware of where the law is going. So, hope you're all with me. Let's get going. Moving on, I've got 3 slides here. I'm not going to dig into them. So next slide, please. And then the next one. There are three, in broad strokes, there are three primary types of equity that we tend to think about: stock options, RSUs, and PSUs. I've given you the descriptions here. When you receive the PowerPoint and this presentation in a week or two, you're going to be able to dig into it a little bit more if you don't know this area. There are other types of equity comp. They're rarer, and I'm not going to touch them at all. All of the case law deals with primarily stock options and RSUs. Moving on to the next slide. Not a meme, but my visual of what the world of this area looks like. It is all over the place. Very confusing, and our courts haven't decided how to handle it yet. So personally, I like to think about all of this as a distinction between an employment law lens on how to deal with equity post-termination on the one hand, and a corporate law lens. And our courts haven't figured out what the right path is yet. Now, that's a bit of an oversimplification of the issue, but I don't want to get too far into the weeds with you. I'm not going to be interpreting case law or legislation with you today, because then you really would turn this off. So that's just really an overview of how I want you to think about this as we proceed. Can I have the next slide, please? I want to take you as a starting point to where we've come from, which is a Supreme Court of Canada case from back in the depths of COVID, when we were all working from home on Zoom and eating sourdough bread, called Matthews and Ocean. Matthews and Ocean is not an equity case. It's an LTIP case, which is a long-term incentive plan. But a lot of the basic principles in here seem to hold true, and it's from the Matthews case that we get this employment law lens that I'm going to talk about. So Matthews said that when you're trying to figure out whether an employee is entitled to damages for breach of the implied term to continue bonuses and other benefits during a common law notice period, you have to look at two things. Number two is the key point. Is there something in the applicable plan which specifically takes away that employee's entitlement to that thing? In this case, the LTIP. And in Matthews, the court simply said that no, there wasn't anything in there in that LTIP plan that took away the employee's right to continue the LTIP through their common law notice period, and therefore they were entitled to it. Lots of courts believe that because of Matthews, unless an equity plan or equity agreement or grant agreement has language which also specifically and properly takes away the employee's entitlement to equity post-termination, the employee is going to be entitled to continue to vest those stock options or RSUs during any common law notice period that they're entitled to. So that's our starting point. Can we move on, please? We're going to jump ahead now to 2021. Okay, year later, we're still in the depths of COVID. We might not be eating sourdough bread. We're probably watching Tiger King, whatever it was called. I can't even remember now, but there are lots of touch points. One of our touch points is the case of Mickelstein's. That came out of the Ontario Court of Appeal, and in this case, Mr. Mickelstein's had shares in a company, plus he had a bonus that was based on a percentage of his shareholdings. It was determined strictly on objective company financial results, so it was sort of like a dividend. His shares were voluntarily purchased by him and were not part of his compensation, according to all of the documents. But, like, really, would he have received shares or a bonus based on his shareholdings if he wasn't an employee? To me, that's the key here. But in this case, the court found that because the shares and the share bonus weren't part of his compensation or tied to his performance as an employee, the employment-based test under Matthews didn't apply, and his rights were to be governed by his shareholders' agreement. There was a lot of to and fro. This case went to the Court of Appeal twice. In fact, after the first go-round, it went up to the Supreme Court of Canada, which had just decided the Matthews case. And the Supreme Court actually told the Court of Appeal, go back and take another look at Mickelstein's through the lens of Matthews. They went back, they did that. They clearly didn't think much of Matthews because they ultimately determined that Mr. Mickelstein was entitled, Mr. Mickelstein's entitlements were to be determined based on what I call the corporate test, which is This has nothing to do with employment. Let's not look behind that curtain over there. We don't have to worry about the Matthews test, and let's move on. And he doesn't get anything. So, as Ferris Bueller's teacher would have said, can anyone explain or reconcile this decision with the fact that he would not have had the opportunity to purchase his shares or to receive a share-related bonus, but for the fact that he was an employee? I don't think so. Moving on, please. The Court of Appeal, 2 years later, took another look at this decision in a different case involving IBM, and they didn't mention Mickelstein's at all. It was like it had never happened. The parties didn't mention it. The Court of Appeal didn't mention it, even though the judge on the motion prior had mentioned it in passing and didn't draw any conclusions. This was an RSU case, and the court in this case, the same court that had said no to Mr. Mickelstein's, took a look at the Matthews test and said, there was effectively nothing in that RSU plan which removed his entitlement to continued RSU vesting because the RSU plan was ambiguous, and he ended up being entitled to damages in lieu of the opportunity to vest his RSUs through the 24-month notice period. Let's move on. We're jumping ahead now all the way to 2025. I should add, by the way, there was another case that just came out early this year involving IBM. It came to the same decision as the Millwad decision that I just discussed. In 2025 in Alberta, the Court of Appeal followed the Matthews approach. You can read about it when you get the slides. Again, the same decision the Court of Appeal came to in Ontario. Next slide, please. That very same month, again, July of 2025, we have an Ontario Superior Court of Justice decision in Liggett and Viva. And they followed what the court did in Alberta and what the Court of Appeal had done in IBM and Millwood, and said, no, you got to follow the employee route. And if you don't have anything clear, then the employee is going to be entitled to damages in lieu of the opportunity to vest throughout their notice period. Next slide, please. This is where things get confusing. Last August, just 1 month later, we get the same level of court in Ontario coming to a totally different decision in the case of Wigdor and Facebook. And I want to point out that this case was scheduled to go to the Court of Appeal and in fact was heard by the Court of Appeal in Ontario yesterday. We don't know where they're going to go with this. I am guessing it's going to take a few weeks until the decision is released. Hopefully that's going to help to resolve this issue, although I suspect that it's going to take the Supreme Court of Canada ruling on it before we have any finality. So in this case, there was actually a termination provision in the RSU agreement that said that Mr. Wigdor's RSUs were forfeited as of the date of notice of termination, subject to any requirement to continue vesting through the statutory notice period. And there was a whole argument that went on in front of the court about whether that language breached the ESA. I'm not going to get technical on you. I've already done it in bullet point 2 here. But the court basically said that there is no requirement to continue all terms and conditions of employment during a pay in lieu of notice period. During a working notice period, yes, but not during a pay in lieu of notice period. And because Mr. Wigdor was paid out on termination, this wasn't a breach of the ESA. They then followed a corporate test and basically said, nope, Mr. Wigdor, you are not going to get any damages for that RSU forfeiture. Can we move ahead, please? So where are we now? We are in a place that I simply don't know. I can't tell you with a straight face today where things are going. I think that if this were to go back to the Supreme Court of Canada, my gut feeling is that they would want to follow the Matthews, the employment law track, and say, look, anytime somebody's terminated, and they're entitled to more than statutory minimums, they should be entitled to all of that throughout their larger common law notice period. I think the key is going to come down to how these equity agreements are drafted, whether they cut off on the date of notice of termination, which often seems to be the case, particularly with US-based companies that haven't taken a look at their equity plans through a Canadian law lens, but it remains to be seen. I think it's going to be interesting. I would say stay tuned. We're probably going to have more on this in a few months for you. And if you have any questions, feel free to reach out to any one of our team members. I'm going to leave you with that. Thank you.
Thank you, Catherine, and thank you to all our speakers. We've got a few minutes, 8 minutes to be exact, and we're trying to honor our time commitment to you and your time. There's a couple of questions on the chat line or the Q&A. I don't think we've got time for all of them, but I'll try a couple. The use of using DocuSign or other similar tools to obtain signatures on a release, is a witness signature still required? One of you want to address that? Perhaps Christina?
Yeah, I can take that. I hopefully will not hit the magic button that made everything disappear last time. Yeah, so with the DocuSign, like the point of a witness is if you run into a situation where you need to prove that the release was signed. So that case I mentioned where the employee was saying, that's not my signature, that's a forgery, the employer forged my signature. If you had a witness, then you could get some testimony, evidence from the witness to say, no, I was there, I watched that employee sign it. So DocuSign can step in as a witness. I'm of two minds for this, and this just came up recently, where the employee was in a situation where they were going to sign it by DocuSign, needed a witness on the standard form of release, but how do you get the witness to sign by DocuSign without sending them the form of release, which effectively takes away the confidentiality provisions? So my thought there was, look, you have the DocuSign that provides some measures, some security to say, this is the employee that signed that document and steps in for the witness. Open to other views. I haven't seen this discussed anywhere. It was just my thought process on how to deal with that issue.
Great, thank you for that. A question for Craig regarding resignations. Must the resignation, sort of a combined question, must the resignation be accepted in writing? And who is responsible for accepting it? Is it HR? Is it the employee's manager? And when accepting that resignation, does it have to come from one or the other person, i.e., who should be responsible for saying we accept?
Yeah. We get this question actually quite often around, who's going to wear this if we're going to get into a fight after the fact. Really, it's anyone who has authority at the company to do so. If you want it to be the manager, great. If you would rather HR be the one who is stick handling communications like this, wonderful. Um, the big part to me is that it be in writing. The verbal response, it's just so hard after the fact to establish what was said and who said it. It's much easier to send an email. Most organizations will say, well, we want HR's line of sight on resignations in any event. So have an HR rep do it. That's fine. But there's lots of small shops where a manager is doing, a bit of dual hatting, and that's okay too.
Okay,
I
thank
did
you.
see, Scott, just there was one more question in there around resignations, and it's sort of a two-parter about
Yeah, please go. Thanks.
how do you motivate someone to resign, and how do you have those sort of mutual conversations around resignations? Uh, and I think the simple answer for this is there's no way to, quote unquote, safely tell someone that they're going to resign. What you're really contemplating there is a mutual negotiation for a separation package. That's not really a resignation. You might frame it as one of the terms of that settlement that they are resigning and that'll be communicated to other staff as a resignation. But the process you're really engaged in there is, an open dialogue around their future and, are they happy there? But that, needs to be viewed within the context of what it actually is, which is a negotiation around a separation agreement. As soon as you open that door, you need to be ready for that conversation to go in a bunch of different directions.
Right.
And assuming that you're going to be able to wedge it into this idea of a resignation is going to be tough.
So context matters and who you're dealing with matters, obviously.
Very much so.
One last question before I do a little bit of housekeeping for Rachel. We're short of time, but the question is regard to the case you cited, Rachel, the Plume case. would you suggest that we have all employees who've undergone a change in their employment status enter into a new agreement? For instance, have gone from a customer help person to a sales manager. Should that employee, if it's significant enough, be presented with a new employment contract? Is that best practice?
Thank you very much for that question. It's a really important question. So as I mentioned during the presentation, so basically we would need to review the initial job responsibilities. So I wouldn't want to give a blanket answer of, oh, everybody who's gone through a job change should have their employment contracts renewed or amended. So basically the first step would be to, go through, review the initial employment, their job responsibilities to see whether or not there's been fundamental or significant changes to their responsibilities, which might in turn trigger the change substratum doctrine. And then based on the specific example of a sales rep person, a customer help person, then becoming a sales manager, I want to say that might be one of such situations whereby you might need to, look at this person's responsibilities and consider having them sign a new agreement, a new employment agreement that should reflect the new terms of their employment, considering the jump from their duties from being a customer help to being a sales manager. But again, that's also, based on the facts and something we would need to review. Thank you.
Thank you for that, Rachel. We're running out of time, and I've got a couple of housekeeping matters. First of all, thank you to the panelists for their, I thought, really interesting comments. As I say, I overlap with a lot of you on my world, and you're always helpful to me because I put together structures and then I turn around and say, what's the employment issues? And they're always there for me. And so we make a great team. So I hope you enjoyed this session. I hope it provided what we really do emphasize at Denton's, which is practical, business-focused strategy, not hit you with the law constantly, help you navigate terminations, resignations, broader workforce strategies and changes, and mitigate risk to ensure compliance, so avoid lawsuits.